Welcome everyone, and thank you for joining us. It's great to see everybody today. My HoChunk name is Good Woman. My English name is Trisha Zunker, and I am a law professor and a member of the board of directors of Midwest Environmental Advocates. I'm also a HoChunk tribal member. Midwest Environmental Advocates is a nonprofit law center that combines the power of law with the resolve of communities facing environmental injustice to secure and protect the rights of all people to healthy water, land, and air. Recently, the Wisconsin Supreme Court refused to take up a lawsuit involving Meteor Timber's request for a wetland fill permit. The permit would have allowed the out-of-state frac sand company to destroy rare forested wetlands in Monroe County. The court's refusal to take the case brought a successful conclusion to nearly 5 years of litigation. We're here today to talk about the case and what it can teach us about natural resource protection, government accountability, and public participation. I'm joined by retired DNR attorney Michael Kane, former secretary of the Wisconsin Department of Natural Resources and first executive director of the Wisconsin Wildlife Federation, George Meyer, Clean Wisconsin attorney Evan Feinauer, MEA Executive Director Tony Wilken-Gibart, and MEA Staff Attorney Rob Lee. We were also supposed to be joined with HoChunk Nation Representative Conroy Greendeer, who cannot be here tonight due to unforeseen circumstances. Our discussion tonight will include an opportunity for those of you who joined us to ask questions of our panelists. If you have a question, you may use the Q&A feature at any time. Q&A button can be found at the bottom of your screen. You may also type your question into the chat. All right, let's get started. Tony, can you tell us how the case began?
I'm on my phone. Okay.
Yeah, I would be happy to. So this case began after Meteor Timber applied for and received a wetlands fill permit from the Department of Natural Resources. The company claimed that it needed this fill permit to construct a load-out facility and a rail spur that would move frac sand materials from Monroe County near the mine to a processing facility in Jackson County. DNR issued this permit despite the fact that the company didn't supply sufficient information for DNR to even determine adequately the impact that this fill would have on the surrounding ecology. In addition to that, one of the requirements for a permit is that the company design and implement a mitigation plan to make up for the loss of the wetlands. And in this case, DNR's own experts agreed that the plan as designed would fail, that it wouldn't work. So in short, DNR should have denied the permit to fill these wetlands. But in fact, the permit issued and it would have allowed for the destruction of 16 acres of pristine, exceptional wetlands. And because DNR did issue this permit, MEA, Midwest Environmental Advocates, as attorneys for the HoChunk Nation, and our co-petitioners at Clean Wisconsin filed for a contested case hearing. We asked an administrative law judge to invalidate this permit. That led to a hearing in 2018 where there was 5 days of testimony from experts. After that hearing, after that process, we won, and the judge did invalidate the permit. That hearing revealed that the permit had been originally issued by DNR managers over the objections of scientific staff. It looked like, by all appearances, a textbook case of political interference. And the expert testimony at that hearing revealed that not only would these irreplaceable wetlands be destroyed, but we would also lose critical habitat for threatened and endangered species and critical ecosystem services like flood prevention. So that's how the case began, Tricia.
Thanks, Tony. As we know, however, that initial legal victory turned out to be just the beginning. Rob, can you lead us through a basic timeline of what occurred after that first legal victory?
Yes, I can. Thank you. After the ALJ issued his decision in May 2018, MEA and Clean Wisconsin then had to defend and successfully so that initial victory when Meteor Timber tried to persuade the DNR secretary to reverse the independent administrative law judge, or what I'll refer to as an ALJ's decision, using a procedure, a little novel procedure in the administrative code. So although the DNR secretary initially granted review of the ALJ decision pursuant to this petition under this administrative procedure, and after extensive briefing by the parties, the secretary ultimately took no action, and in May of 2019 issued a decision keeping the ALJ decision intact. In addition to that, DNR did not appeal the decision, which actually made the ALJ decision become DNR's decision. So on appeal, after the ALJ decision, DNR was actually defending its own decision, invalidating the permit that it had adopted. So at the same time, the DNR secretary was reviewing the ALJ decision. Meteor Timber did appeal that decision to Monroe County Circuit Court to reinstate the permit through a process called judicial review. MEA and Clean Wisconsin were once again successful in defending the decision when the Monroe County Circuit Court judge upheld the ALJ decision in September 2020. After that, Meteor Timber appealed the circuit court decision to the Wisconsin Court of Appeals. They filed that appeal in late 2020. And the following year, in a published decision on December 16th, 2021, the Court of Appeals again affirmed the ALJ's decision to invalidate the permit. So after that, Meteor Timber had one last chance, and that was through a petition to the Wisconsin Supreme Court to hear the case. And so while all litigants typically have the right to one appeal from the circuit court up to the Court of Appeals, and another appeal up to the Wisconsin Supreme Court is not guaranteed. The Wisconsin Supreme Court gets to decide whether or not it'll hear the case. And so here, after 5 years of litigation, after the first petition for a contested case hearing was filed all the way back in June of 2017, in April of 2022, the Wisconsin Supreme Court denied the petition from the Court of Appeals, leaving the published Court of Appeals decision intact and formally putting an end to Meteor Timber's attempt to destroy these irreplaceable wetlands once and for all.
Thanks, Rob, for recounting the long and winding road of this case. So I want to go back to Tony for a moment. Tony, why was it so important for the HoChunk Nation to see this case through? What impact would Meteor Timber's project have had on the nation?
Yeah, thanks, Tricia. And if Representative Green Deer were here, he would say this much better than I could. But one thing I've learned from you and other HoChunk leaders is that the tradition of the HoChunk people states that the HoChunk people have always been here. And here means where I'm standing right now, literally Madison, Wisconsin, day joke. It also means large portions of what we now call Wisconsin, Minnesota, Iowa, Illinois, and Missouri. And it includes, of course, Monroe County, Wisconsin, where the wetlands are located. So it's that kind of longevity and care for this place that is not only present, but is something that was maintained by the HoChunk people during successive campaigns of attempted forcible removal by the US government. And despite that violence, the HoChunk people in some cases remained, and in many cases returned to this place to continue their relationship with the land. And so I think it's in that context of that deep, abiding, generational care and relationship to this place that it maybe becomes apparent why the nation would be opposed to what we saw in this permitting decision, a politically expedient decision to destroy irreplaceable natural resources, all for a highly extractive, harmful industry that sees its mission in terms of really short-term booms and busts. And we've talked about the fact that this case has taken 5 years to get to this conclusion, and that may seem like a long time, but I think in the context of the HoChunk Nation's care and concern for this place over generations, that is actually, by that measure, quite a small amount of time.
Thank you for that, Tony. It's always so wonderful when we can see, we as HoChunk people can see that there are others who understand that we do have this duty, this tradition within us that says we're supposed to take care of this land, not just for us, but for generations ahead of us. So I'm glad that you were able to learn that and to share that so succinctly. So I would like to turn to Evan, please. Now, clearly, these wetlands have tremendous ecological and cultural significance. But what exactly went wrong at the DNR that led to the initial decision to issue the permit?
Yeah, so good night, everyone. And thanks for tuning in. So, under state law, there are pretty clear requirements for what it takes to get a permit issued. And as Tony mentioned earlier, the applicant for a wetland permit has to submit a plan for making up for the impacts to wetlands that their project's going to cause. And the plan that was submitted, that DNR had at the time it decided to issue the permit, was incomplete in a range of different ways, including failing to include information that is set out in regulation is required as sort of the bare minimum. And so that right there was sort of a, sort of step one problem, sort of right from the get-go. They had mistakes there that shouldn't have been overlooked. And then more substantively, or even more substantively, state law requires that when all is said and done, you've done the mitigation, you filled in the wetlands, that you're not going to have a significant adverse impact on wetland functional values. Basically, the net effect of your project plus your mitigation isn't going to be harmful to the environment as far as wetlands are concerned. And there was no way that the department could conclude that reasonably based not just on the information that they were missing, but on the information that they had, which showed that they were certainly going to permanently destroy these really high quality wetlands with a pretty slapdash plan to make up for it with this mitigation. And it didn't take a whole lot to see that the science just wasn't there behind this. And so the question then is sort of what went wrong that this permit got issued anyway? And they attempted to give this company more time and additional opportunities, even amending a permit in a way that was completely unauthorized by the statute, to try to give them extra chances to get this missing information in and to overlook certain things. And it's hard to escape the conclusion that they sort of made the decision to issue the permit and they were going to do their homework later to try to make it approvable, which is, of course, completely upside down. And that was why, it was sort of a no-brainer to bring this case, because both the resources that were going to be impacted and the flouting of state law were pretty egregious in this instance.
Thank you, Evan. So, Tony, what does this case tell us about our role in environmental protection? Do members of the public have a right to challenge environmental decisions?
Thanks, Tricia. Yeah, so to take that second part first, yes, members of the public do have the right to challenge agency decisions, including the decisions of the DNR. And to the first part of your question, I think, what Evan just described, it demonstrates that sometimes exercising that right is crucial to protecting what would otherwise be the loss of irreplaceable resources. So in this case, the administrative hearing process allowed Clean Wisconsin, allowed Midwest environmental advocates, allowed the HoChunk Nation to have an impartial decision maker take a closer look at whether DNR should have ever issued this permit and whether it was correct under the law.
So Tony, let's back up for a moment. What is an administrative hearing and how does it work?
Sure. So under Wisconsin law, members of the public have the right, as I mentioned, to challenge agency decisions. And the way that they do that is through the administrative hearing process. Administrative hearings are sometimes called contested case hearings, and they are basically designed to resolve disputes about agency authority, about the correct application of law to factual circumstances. And so they function in a way similar to a court trial. A hearing examiner, also called an administrative law judge or an ALJ, runs the hearing much like you would see a judge run a court trial. So lawyers represent the parties who are interested in the matter. Individuals who are presenting information do so as witnesses, and they can be cross-examined by the lawyers and by the hearing administrator. And once all of that information is in the record and considered, the ALJ makes a decision about final determinations of law and fact, and those decisions can, in fact, reverse the original decision of the agency, which happened here. And so that brings us back to, the original question about, what does this tell us about our role in protecting natural resources? And I think this case demonstrates that the scrutiny of the contested case process or litigation generally can be an antidote for politically motivated decisions that never should have happened in the first place and that would squander priceless natural resources. And, it's true, as we've talked about, this took many years. This process is not an easy one. It requires time, money, and expertise, but it is important for us outside of state government that we have this check, that we can exercise balance and have the legality and the soundness of decisions scrutinized, especially when state government might be too cozy to industry, which is a subtext certainly to what was going on in the Meteor Timber matter.
Great, thank you so much for that helpful explanation, Tony. Turning to Michael. Michael, you worked as an attorney at the DNR for many years. What would you say to those who've observed that what happened with this permit seems to fit pattern in which the recommendations of scientific experts within the DNR were overruled?
Well, thank you for inviting me to participate. I hope you can hear me. I was at DNR for 34 years as an attorney. I worked for 7 governors and 7 secretaries. And in the old days, I don't think the DNR operated this way. The Meteor permit, Kohler Golf Course permit, a number of other permits, staff were not allowed to do their job. After being contacted by Midwest Environmental Advocates, I talked to some of the staff who had the temerity to stand up and say that we cannot issue this permit, we're removed from the process. That had not happened historically, at least in my experience. I think that this demonstrates the importance of citizens and groups who participated in challenging the permits at Meteor. I think it's critically important to protection of the state's resources. One thing I want to say to people who are citizens who are participating is that you shouldn't demonize department staff. My experience is that 95% of the staff are there to protect the state's resources. In this particular case, staff thanked us profusely when George Meyer and I went and testified at the legislature and testified at the hearing. And they were, they can't say this, but they were happy that the citizens stepped up and that these groups stepped up and helped them protect this resource, which should have been protected. I think this whole issue demonstrates the importance of Clean Wisconsin, of MEA and HoChunk and other groups and all citizens stepping up to protect these resources.
Thank you so much for sharing your experience and observations. And you referenced George testifying at the hearing. So let's turn to George. George, you testified during the 5-day hearing in 2018 as the then executive director of Wisconsin Wildlife Federation. Why was it important for you and your organization to participate?
Well, there are 2 major reasons the Wildlife Federation became involved, and a little bit of our background will explain why. Wisconsin Wildlife Federation is made up of over 200 sports clubs throughout the state, hunters, anglers, trappers. Part of our mission, one of our major parts of the mission, is to advocate for good, sound conservation laws to protect all kinds of wildlife species, even those beyond what we'd call game or huntable species, endangered and every other type of species, and their habitat. Over the years, the Wildlife Federation, many other conservation groups have been strong supporters of wetlands protection in the state. We rarely get involved in regulatory or enforcement decisions, administrative agency decisions, just because we have 2 staff, broad mission. We work on the broader policy side. Other organizations such as Clean Wisconsin, Midwest Environmental Advocates, and other citizens and citizen groups really are on the front lines when those laws are being applied, either correctly or incorrectly, by the Department of Natural Resources. But every year or so, we get involved in a case that we really feel has major implications to the interest that we represent, which are wildlife and species. And we looked at this case and were shocked by the size of the wetlands that were being proposed to fill, which was totally abnormal to the regulatory history of the department, over 16 acres. And then digging into it with the information we received from Midwest and Clean Wisconsin, and by talking to staff, these were really some of the finest wetlands there are in the state, really top tier wetlands. So we became concerned that this would be a terrible precedent if they could fill these wetlands and that acreage. There really wouldn't be much protection from a precedent standpoint for filling in many more wetlands. So that was one reason we're involved. The second reason is we work hard, as other groups do, to help establish strong conservation and environmental laws in the state. But that's only part of the battle to, in fact, protect natural resources. If the agencies that are involved with the implementing those laws don't do their job or aren't allowed to do their job, you can have the finest laws you could ever design, but if they aren't being applied, you don't have any protection of natural resources. So along with Mike and information that we received from staff, we saw how blatantly political this had been, where staff were being removed and replaced by people that were by top people that made the decision. There was still courage exhibited by staff, because if you read the permit, the findings of fact, which are the background of why a decision should be made, talked about how valuable things were and how bad their alternative proposal was. So staff showed courage of getting that information into the permit, but then the permit was ultimately denied. So our job was, we felt as a group, was to fight this political interference that was undermining our laws. And particularly, Mike and I know some of these staff are some of the finest professional scientists in the country on wetlands. So that was the second reason we became involved.
Thank you so much. Rob, there were others outside of the DNR who attempted to influence the decision to issue the permit. Can you tell us about the state assembly's attempt to use the legislative process to influence the outcome?
Yeah, well, it was really Meteor Timber's attempt to use the legislative process, right? Getting friendly members in the state assembly, right, to try to take action and introduce amendments to legislation at the 11th hour, right, at Meteor Timber's behest. But the state assembly did do that and passed an amendment to some wetlands related a wetlands related bill, and added a exemption in there, a provision in there that would essentially have exempted Meteor Timber from the wetland permitting requirements and allowed the project to move forward. And Evan, maybe you can correct me if I'm wrong here, but I believe that went through the assembly right before the contested case hearing was set to start, right? Evan, right before you were forced into that room without windows for 5 days, right? To establish the record here. So really at the 11th hour, right? Trying to hand Meteor Timber a win before they'd really even been able to discuss the facts of the case, because they already understood that they didn't have a good case. Now, ultimately, while the assembly passed that effort failed overall. And of course, Meteor Timber wasn't granted that exception, but we've seen the legislature take similar actions with respect to other projects. So it certainly was a possibility that went all the way through, right? And that we would have been deprived of this ultimate victory here in defending and upholding our laws, protecting our state wetlands, right? But I think it also goes to show that you can't only have one tool in the tool belt, right? And solely stay on litigation or the courts, right? You also have to be prepared to fight it out in other arenas, like before the legislature, and in that capacity too, to really make sure you secure victory all the way across the board. So yeah, that was defeated, and I think a testament to the hyper vigilance of everybody involved at the time, but certainly a scary moment. I'm right there before MEA and Clean Wisconsin had the chance to even make the case.
Thank you for sharing that summary, Rob. So at this point, I'd like to give those of you who've joined us an opportunity to ask questions of our panelists. If you'd like to ask a question, please use the Q&A feature at the bottom of your screen or type your question into the chat. So let's see, do we have any questions here? Oh, we have a question from Paula Mohan. Hi, Paula. Thank you so much for joining us tonight. So Paula has two questions here, and I'm just going to actually open this up to the panel. Isn't Act 21 being passed in 2011 preventing the DNR from actually doing its job? How do we bypass the legislature? Who would like to start answering that?
I will start. So for those who don't know, Act 21 is a bill that was passed in 2011 that made major changes to the administrative rulemaking process in Wisconsin, and that's the process by which the DNR and other state agencies update public health and environmental protections. It's a real barrier. It also purported to change and restrict agencies' authorities to make permitting decisions to protect public health and the environment. And so the question is definitely right on, that this is a huge, huge challenge, but I think it's a challenge that also speaks to the importance of Midwest environmental advocates, Clean Wisconsin, and the participation of groups and citizens around the state, like Michael was saying. It was Clean Wisconsin and Midwest environmental advocates that litigated an important set of cases around the meaning and interpretation of Act 21 last summer before the Wisconsin Supreme Court, and achieved really important victories that preserve water protection authority in Wisconsin. And just yesterday, we saw PFAS regulations move forward past legislative review, despite all of the hurdles and obstacles that Act 21 presents. And that's because there were local leaders and directly impacted communities participating at every stage of that process to force those protections through. They're not nearly as strong as they should be, but they are going into effect because of the organizing effort of groups and people around the state. So it's a really, really critical question that I think underlines a lot of the themes that we've been talking about here today.
Great, thank you so much, Tony. Does anybody on the panel have anything to add? That was a comprehensive answer, so thank you, Tony. We do have another question here from an anonymous attendee. Thank you so much for attending. And the question is, what specifically was the last minute exemption? So does Rob or Tony perhaps have an answer?
Well, to clarify, I don't think it was an all-out exemption saying you don't need a permit at all. I think it exempted them from specific requirements, and the ones that were being challenged, right? The requirements that they didn't meet, which would result in them getting a permit. Evan, is that right? Or feel free to correct me if I'm way off.
It was an exemption from the permitting requirement, but it was, it was written because they can't write, hey, Meteor Timber, you don't need to get a permit. That would be unconstitutional, actually, because it'd be special legislation. But so what they do instead is they say, well, if it's sort of like, this isn't a law about Evan, but if you happen to be about 5'10" and you're 34 years old and you live on, East Main Street in Madison and you have 2 kids, they basically just set out a list of attributes that really only could apply to one project, and then said, if that happens to be you, I guess you don't need a permit. So it was kind of like trying to achieve the same outcome of saying Meteor Timber, you don't necessarily need a permit, just by describing details. And I think the way they did it was describing the particular mitigation mechanisms that Meteor Timber was going to employ, and saying like, well, if you are going to fill this kind of wetlands and then you're going to do this to try to compensate for it, then we're just going to call that good enough. And I think the way they tried to sell it to the legislature, to the extent it needed selling, was, well, look at all the good things that they're claiming on paper they're going to do. And so surely this merits not needing to go through the process that literally everybody else in the state needs to go through if they want a wetland permit. That's my recollection. I spent a lot of time looking at it when it was introduced and passed the assembly, and have mercifully not needed to think about it much for the last few years.
Well, it reminds me of another exemption that did get passed, say for the Foxconn project, right? The electronics and information technology zone, which I'm pretty sure did the exact thing that you described, right? Didn't say Foxconn, but basically described the thing that Foxconn wanted to build there, and exempted them from certain requirements. So certainly a tactic we've seen in other contexts too. So, but great, thanks for the additional info, the assist.
Great, thank you so much, Rob and Evan, for your answer on that. So question opening really to the panel, but I think we'll start with George, if you don't mind. How did you maintain momentum when this case stretched for over 5 years?
The Federation became involved during the hearing process and also in the legislative process. We were not a party from the start. We just don't, as I mentioned earlier, we don't have the resources. We've been involved in litigation before, but it's because through the good graces of being represented by Midwest environmental advocates on several water and air pollution cases. So we became involved along the same time Michael did when we were hearing about the problems on this permit, talked to staff, talked to those involved, and then when the hearing process became involved. We didn't have as long a battle as, in fact, HoChunk and Clean Wisconsin did. And they're really to be praised for their efforts, for being the backbone, really, of the protection efforts.
Great, thank you, George. Anybody else want to weigh in on how you're able to maintain momentum when cases like this stretch over years and years?
Well, I'll just add, I think one of the features of this process is that, as we've been talking about, a lot of the work and the factual record for the invalidation of the permit was developed at the contested case hearing. And because Clean Wisconsin and MEA did such a great job at that stage of the litigation, certainly there was a lot of work to defend the victory throughout the judicial review process. But I think we all felt confident that we had by far the stronger arguments because the law and the facts were on our side, and that was ultimately vindicated. So I think the knowledge that that we were in the right helped sustain us throughout the years.
Absolutely. Thank you so much, Tony. So we have a question from Glory Adams. Thank you for joining us tonight, Glory. And the question is, do any of you know what the future of this wetland is? The original owner had said he was going to clear cut it for lumber. Anybody know the future of this wetland?
Well, I don't know that anybody, by definition, nobody knows the future, so, but we can speculate. So the background on this is that the gentleman who owned the land that was going to transfer ownership to Meteor Timber so they could build this frac sand transloading facility claimed that he was going to clear cut this entire forested wetland. as a sort of, give me the permit to destroy this wetlands or else I'll destroy the wetlands kind of threat. And, if you have timber on your property and you own the property, you can dispose of it, within limits in certain ways. And you can definitely try to, harvest timber for sale if you want. Our understanding at the time was that logistically it would have been difficult to clear cut it, given the topography and the fact that it was largely a wetlands. And also that there was little in the way of clear indications that this was actually imminently going to happen. The interesting backstory too is that the reason that this guy said he was going to clear cut it was because he needed to raise cash. And the reason he needed to raise cash was because he was subject to an EPA fine, a very large EPA fine for illegally filling a wetlands without a permit. So irony here, right? And it was the thing, and this was a real thing that we talked about is, if they're going to clear cut it, how does it implicate the case and our strategy? And I think the thing that sold me was talking to, our wetland ecologist who had testified at the hearing. And she said, in the long term, if they fill it, it'll be permanently destroyed. If they timber, a lot of the overstory will be removed. But over a lifespan that's maybe not significant to you or I, but to nature, it'll come back. In 30 years, 40 years, 50 years, you could come back and see large trees again. And so that's actually a preferable outcome to letting them totally fill in the wetlands and turn it into a transloading facility. So it was a sticky problem in the case for sure.
Thank you, Evan. So let's see, are there any other questions? Our Q&A. Any other questions? I am not seeing any other questions. So I want to thank everybody for joining us. And on behalf of the board and staff of Midwest Environmental Advocates, I'd like to thank our panelists for sharing their knowledge and experience. You can find out more information about the Meteor Timber case at midwestadvocates.org. Waini Ganachana.